Hello, here I am on Wheat Lane, which is in Lathom. So we're just outside of Ormskirk, and you can see behind me a very picturesque row of turn-of-the-century cottages. That's 19th to 20th century. And then right at the end is the pub, the Ship, a very nice gastro pub. So the houses sit on the intersection of the Leeds-Liverpool Canal and then the Rufford Canal. But I'm not here to talk to you about this part of Lancashire. Instead, I'm going to talk to you about the early 1970s case of Gissing and Gissing, which went all the way up to the House of Lords, but first started with Mr. Justice Buckley at first instance. Then it goes up to the Court of Appeal, where Denning sits, and then right up to the House of Lords with Messrs. Dilhorn, Diplock and Reed, etc. So, why is it important? Well, it's a common intention constructive trust case, one of our early cases that has elements that we might find of interest because of the kind of activity that was undertaken by the couple in the case, a married couple. So what were the facts? Well, they were these. They got married, did the couple, stayed in a flat. The husband fought in the Second World War. Upon demobilisation, he obtained a job because of his wife's help at the printers where she worked. She was a secretary. He did rather well at that job and was sufficiently remunerated to be able to afford a house. So they bought a house together, in the sense anyway that the sole legal ownership was his. She did undertake some of the financials, so he got the mortgage, largely the deposit, and other financial elements that helped get them the house, including a loan from his employer. She also did provide some financials in the sense of paying for her clothes, paying for the son's clothes that they eventually had, a child, and then paying for some furniture and also paying for the lawn to be turfed in the house. So the question before the court was, could you infer some form of agreement between the couple whereby the wife had come to a position where she had a beneficial interest? Was the activity I've just outlined sufficient to show that she'd acted to a detriment, thinking that the husband would respect that activity, giving her a stake in the house, a beneficial interest? At first instance, Mr. Justice Buckley says no, there was insufficient activity done by her, and indeed there was no agreement, either express or that one could infer from their relations over the course of their marriage. Goes up to the Court of Appeal, where of course Lord Denning does find that she has an interest. This is just before Eves and Eves, of course, so it's probably to be expected that Lord Denning would operate in this way. Then it goes up to the House of Lords, where I implore you to read all of the judgments, but the one that's perhaps the most expansive and explains the development of how we infer or impute a common intention constructive trust is that of Lord Diplock. So have a look at his judgment, and of course Reed and Dilhorn as well, and the other Lords of Appeal. But when you look at Diplock's judgment in particular, you'll see that he outlines the idea that a common intention constructive trust is something that can give an interest to a spouse in the joint matrimonial home, other than using the statutes that the legislature have provided for married couples. That's to say, trusts interposing into married relationships to allow a finding of a beneficial interest. And in so doing, though, he then analyses the facts of this case, Gissing and Gissing in particular, and holds that Violet's activities, and indeed Raymond's, the couple's activities, were not sufficient to be able to infer a common intention constructive trust so as to be able to give her, Violet, a beneficial interest. So the first instance decision of Mr. Justice Buckley is reinstated, meaning that she has no interest. So in another equity short, we will address Pettit and Pettit and see how that case relates to this. But from this beautiful and scenic part of Lancashire, Wheat Lane, I bid you goodbye. Goodbye.